They say technology makes our lives easier. For work, to learn, to travel, to communicate. But there are things that machines cannot yet do. Things as important as engaging, putting themselves in your shoes, having intuition, or making intelligent decisions. In an increasingly technological world, we need professionals who provide intelligent solutions based on their know-how. Because there are things that technology cannot yet do for you. The human tech.
Good afternoon, everyone, on the 2nd of October 2024. Today, we're going to talk about this important topic. In navigating inheritance laws in Spain can be challenging for all of those involved. All right, I've got in the panel Pedro Heredia, that he's in Alicante today. Hello, Pedro.
Hello, Ignacio. Hello, Michael.
Hello, Pedro.
Right.
Again.
We have Mr. Davis in the south part of Spain. We don't know where he is, in Almeria. Hello, Michael.
Hi, I'm working from home in the middle of a refurbishment job. So.
Oh, my goodness.
You can hear the odd worker calling out for me, that you know what's happening.
Right, we have the privilege today to have Michael Davis from the south part of Spain, a specialist on inheritance. Very much knowledge of it. And we have Pedro Heredia, who's an international lawyer as well and has a lot of knowledge. Pedro will cover the Costa Blanca region in general, and Michael Davis will talk about his experience about inheritance tax and probate and wills. Please start sending us your questions from now onwards. We've got 1 hour of our time. Very precious time. I know, Michael, Pedro, we're all busy, but we really thank you for your time. Please send us your questions through the chat. Tell us where you're coming from, where you are at the moment. Nationality is very important, you mentioned, and whether you are a tax resident or non-tax resident. Right, I'm going to pass over to Pedro, who's going to do the presentation about inheritance tax in Spain. Over to you, Pedro.
Okay. Thank you, Ignacio. Hi, Michael. Obviously, today, the topic that we're talking about taxes, or we will talk about inheritance, we will talk about wills, obviously has an infinite scenario. There are many situations that obviously we will not be able to cover. We will try to cover, obviously, the general issues and obviously answer as much as accurate as we could to those questions that we received. First of all, I would like to start, because many clients says, okay, what do I need for an inheritance? What kind of documents? Let's put them on right, just mention them in order to, everyone to know what it's needed whenever inheritance comes. Obviously, we could be able to speak about them, and then we will enter on taxes and in general and basics about taxes in Costa Blanca and also in Andalusia. Michael is a very experienced lawyer on inheritance, and obviously it is something for us important to help and inform people about inheritance, that sometimes is needed, some issues, sometimes it's not. For example, today I have a client that says, I want to apply NI number for my children, because whenever they're gonna, I said, it's not needed. Whenever it happens, it will be the time in order to apply for the number for them. At this time, we don't have any argument in order to do it. But so, okay, I will put up in a panel probably, the main important documents that we need in order to start an inheritance from someone. This is NI and passport of the deceased person on a beneficiary, if they are residents in Spain, as an NI number. If not, obviously, we will have to apply for the NI number, which is a tax number. And padrón is like a certification where someone is living in a municipality in Spain. Padrón is like we need a historical background where he's living, and a certification from that municipality to see that that person is living in that municipality. This is important to see that it was living in a place, it has a home, it has a permanent home living, because there are some deductions on that. Obviously, the will. I mean, the will is extremely important if it's made a will or not. We will speak about that if it's just should be a Spanish will, or could be also obviously another will not being done in Spain. If it's resident, if it's a tax resident, if it has been making the income tax declaration, that's also important. There are some small tax that is something that normally the lawyers we do, which is model 790. And obviously, from the point of view, we need to apply some special registry about what is the, in order to have a certification to prove which is the last will. And obviously, with that, we need a death certificate. Death certificate, and then we get a document from the registry in Spain, which is in Madrid, to know what is the last will. The last will was made in the notary office in 18th of September or 2019. So that will be the last will. So that certification will say that the last will was made in that notary, and then get this copy of that will. And apart from that, all the assets, I mean, the bank accounts, a deed, I mean, just to understand, I mean, the property about the local rates, for example, the IBI, Suma, in this case, in Costa Blanca, and costs like funeral bills, for example, also will be applied. This is just a brief and summarize what is needed, because we had one client that said, okay, well, I would like you to explain, just summarize briefly what are the documents that we need for an inheritance. In terms of entering in on taxes, inheritance tax or donation gift tax is obviously was a government tax, but it's been given to the region. So in Andalusia, they have their own rules. In Costa Blanca, in Valencia region, we have their own rules. In Catalonia, in Balearic Island, in Madrid. So these 17, 19 special regions, they have their own rules for inheritance and gift. So depending on the disease it was resident or was not resident, if the beneficiaries are resident or not resident, if the assets are in one region or another region, obviously the situation may change or not. So to apply the taxes in, even though it's non-resident, accordingly to one of the regions, because of the assets are in that place. So this is many formulas or many scenarios could happen in these situations, and sometimes it's very complex, and obviously sometimes it's difficult to answer in very rapid, but obviously we will be happy to, if you transmit us your special question that you may have for us to be able to answer. Comunidad Valenciana, in the Valencia region, tax rate in general goes from 7.65 to 34%, and that's in the general. Obviously, there are some deductions, and this is what is a good option, because it was changed last year, in April last year, was drastically changed from 50%, what it was 75, 50%, and it's dropped down to 99% deduction in some issues. But first of all, Group 1, which is descendants, and from lower than 21 years old, it will be 100,000 euros plus 8,000 euros per year under the age of 21, which means some beneficiaries like 18 years old will be 100,000 euros will not be taxed, will be out of the base, plus 8,000 euros per year until 18 years old in this case. Group 2 will be descendants over 21 years and spouses and parents, and again a deduction of 100,000 euros. So that 100,000 euros do not count to be taxed. In Group 1, apart from that, is a maximum rate, which is 156,000 euros anyway. And then we have a group 3, which is really nieces, nephews, uncles, aunts, which has a deduction on 8,000 euros, which is not too much. And then the other group, Group 4, it doesn't have any deduction. The good thing for this is the exemptions that we have, for example, for the main residents. There is a 95% of deduction. So 95% of the main residents, it doesn't count to be taxed with a maximum of 150,000 euros value. So that doesn't count. So in many occasions, if 100,000 euros is going to be taken out of the base, if the main important asset of the formula is also the main residence, and then it drops down the quotient to be paid on 99%, in many occasions, we have clients with a big, I would say, a big amount of asset in order to be received. The taxes to pay is some hundreds of euros, sometimes a couple of thousand euros. So Sometimes it's not too much, really. Obviously, there are different cases or different formulas, but I want to eliminate, I want to avoid these rumors that are about inheritance. It says it costs around 30%, 35%, 40%, or something like that. Obviously, the rate goes from 7.65, I repeat, 7.65 to 34%. But obviously, there are big exemptions on this. Okay, I think this is a brief and summarized details on the taxes which we have in Valencia region. I think I would like to also to listen to Michael, because in Andalusia is also a special rate on inheritance, which is really good also as well. So go ahead, Michael.
Okay, well, you've done a great explanation. As you know, this is what I've been doing now for the last 30 years now, handling inheritance cases. So we've seen a bit of everything. We've seen many changes over the year. People don't realize this, but when they go online and they look at the inheritance tax, they go crazy, because in Spain we've got 17 different regions. Each one has been allowed to create their own exemption amounts. And I read something the other day that said that on average, the regions have changed their inheritance tax rates twice in the last 2 years. So that gives us 34 sets, depending on the date of the person that, when the person passes away. Also, the way that the regional exemptions have been applied to non-residents has changed over the years, because in the old days, the regional exemptions, which were very generous, normally more general than the national level, could only be applied to people that were resident in that region. Then the EU in 2014 told Spain they had to stop doing that, and that if you were a beneficiary, non-resident, but resident in an EU country, you were allowed to claim the regional exemptions with the most connection to the estate. That made a tremendous difference. For example, children that were inheriting from their parents here in Andalusia, for example, in Marbella, on the old system, where they couldn't claim the regional exemptions. If they would live back in London, they were only entitled to €16,000. Now they're entitled to €1,000,000 exemption. So the non-residents can now claim the, people get really confused, because non-residents actually have to present their inheritance tax return to the National Tax Office, but they can claim the regional exemptions if they're more beneficial for them, which in almost every case, definitely in Andalusia and the Valencia region, which are your region and my region, if it's the children and spouse, which would definitely be the case. People have to be careful with this, because it's all done by self-assessment, so they get it wrong, they could end up overpaying. Those now, it doesn't just apply to non-residents. They're resident in the EU. There are sentences by Spanish Supreme Court 2 or 3 years ago. They also extended that to non-residents of Spain that were resident in third countries, either UK, etc. In fact, they did it just in time for Brexit. So nowadays, in general, we've got a series of regions that are very beneficial for spouse and children. And those basically cover the most important ones for non-residents, which, in other words, that is Andalusia, the Valencia region, and the Balearics, which is where most of these my clients are, and now have a very favorable system for children and spouse, who basically pay no inheritance tax. Andalusia, it's exempt up to €1,000,000, and then after that, you pay it with a 99% discount. In the Valencia region, you get the same discounts. In other words, it's not a problem. Now, where inheritance tax still becomes an issue in Spain is once you move over to Group 3. So that's, the brothers, the sisters, the nephews, etc. In fact, just today, the reason why I'm late is I've had a client that's very annoyed, because it's 2 brothers. They're inheriting a large house, and basically their rate is, more or less worked out roughly around that 30%. And they said, I'm reading on the internet that there's no inheritance tax, this, that, and the other. Hardly. Well, but it's not the case for Group 3s. Okay, so there's a lot of, what I always say with inheritance tax is, you need to consult with a solicitor and speak about your exact situation, because, as I say, you've got lawyers in one area of Spain, up in Galicia, and they're writing on their blog, and they're talking about inheritance tax, but they're talking about the inheritance tax rates in Galicia. So somebody goes online and they read it and they think, well, and they get very confused. So that would be basically the other tax that people have got to think about with inheritance is the plusvalía tax when inheriting properties. Quite a few municipalities in Spain, because it's a municipal tax, have now do large discounts when it's the spouse inheriting. For example, Majaca, Estepona, some of the municipalities out in Ibiza have got these big discounts now as well. That's it in a nutshell. I mean, I don't know. But with inheritance, I could sort of just go on and on for all day. I've still, as a lawyer that's been handling inheritance for so long, if I had to stress just one thing, is that people really, they must make sure that they make a Spanish will. Yes, we can all wind up an estate using a UK will after it's gone to probate, but it can cause tremendous problems with the convalidation, especially if it mentions the word trust. Then some people die intestate. That can be sorted out as well. But remember, there are just tremendous problems. First, you have to work out which law is applicable, Spanish law or English law to the distribution. It's very different. In the UK, the lion's share goes to the spouse, at least up to £270,000. In Spain, the lion's share goes to the kids. It's all very different. And the expenses, the amount of money that you'll have to pay in fees to somebody like me to sort out an estate if there is no Spanish will or no will at all. I mean, we're talking about double or 3 times the amount if you've sort of bought a property and made a straightforward Spanish will. I mean, I don't know if anyone has any specific questions. I'm glad to go through whatever questions they are. But apart from that, I think Pedro's done a good job of just sort of going through the basics of how it all works.
Okay, Michael, thank you very much. Could you please, Michael and Pedro, put your email address and your website so people could contact you direct for a specific calculation? I'm sure you do, Michael, Pedro, and ourselves. People might do a simulation case and say, Michael, how much would it cost me if, in this situation, if the law doesn't change, Michael? Because that's something very important, as you know.
Absolutely,
Andalusia and Valencia.
And right at this moment in time, and it's just a rumor, they're playing around with this thing from the national government, saying that they're thinking of introducing a minimum inheritance for spouse and children over all the regions, because the central government is upset the fact that some regions have done away with inheritance tax for the spouse and descendants to try, and they say they're competing with other regions unlawfully by attracting investors in and away from other regions. And at the moment it's just a rumor, but I don't know, you've heard it up there as well, but it's sort of flying around at the moment with the odd comment.
From Michael, actually this is happening. This is pretty much like happening with the solidarity tax and
exactly the same as with the wealth tax.
So the problem we always have is that we can tell you what it is today, but we cannot probably tell you what's going to happen tomorrow.
Exactly.
So, right. Okay, well, then, Pedro, would you like to comment something on top of it, or shall we start talking about...
Yes, obviously we have listened to these rumors. Obviously, it will take, I understand, will take a lot of technical issues in order to be proposed by the government. I think it's going to be very, very difficult, but they did it with the solidarity tax. So it is just something that obviously we will have, we'll be updating obviously our clients about this. It is correct that obviously there's some tax havens really, as Madrid and Andalusia, and in some point also Valencia communities right now has a really good rates. Some of the regions also as well. So it's happening right now that there are some regions that has a really good benefit and some other ones not. So it is really probably people need to decide where to go. It's deciding to go to Andalusia, it's deciding to go to Madrid, it's deciding to go to Valencia because of this issue whenever they come to Spain. Okay.
Do you, Michael, Pedro, before we get into the questions and answers, would you like to tell briefly in a minute why would you recommend always making Spanish will?
Okay, I'll take that one.
Please go ahead.
Okay,
because I think it is quite important.
Okay, so let's start off with just simply keeping things easy. In other words, there's a married couple, they're retired, they come at retirement age or semi-retirement age to Spain. They buy themselves a villa, they have a bank account, sometimes a car. That sort of idea, covers 80% of the people that move over to these areas. If they simply make a will, leaving everything to each other and then down to the kids, or different variations, to protect second spouse against children from other marriages, etc. But fairly simple. We, for example, guarantee that we can wind up probate on one of those wills within 4 months. We always guarantee it, and at the end, we aim for the 3 months to target the thing. If there is no Spanish will, it's difficult to give any kind of guideline, because, for example, if there's no Spanish will, but there is a UK will, I've got to actually wait for probate to happen in the UK before I can even start the convalidation. Probate in the UK can sometimes now take up to 7 or 8 months. So 7 or 8 months, wasted time, because I can't even start. Then there's expenses, the convalidation, etc., etc. Then, if you don't make a Spanish will, you won't be receiving inheritance tax advice by somebody that knows about it. For example, in the UK, you tax the estate. In Spain, you tax the beneficiary depending on his relationship with the deceased. So somebody may come out to Spain, commit a really silly mistake, and sort of leave their asset in Spain to their nephew, and then leave the majority of their assets in the UK to their children. It doesn't make any sense, because that you want the asset in Spain to go to the children, because then they benefit from the €1 million exemption, and the other way around. There are all sorts of, there's just so many different things where it can go wrong if you don't have a Spanish will. Then if you have a Spanish will, there are plenty of lawyers that can compete and give you a budget for the work to wind up your estate. It's a very competitive market, so cause it's like a conveyance almost, etc. Once you start leaving that and you go over to probate with no Spanish will, or an intestate process, you're going to need an expert to wind up the estate. And then it's going to be more expensive, because there are less lawyers like myself, should be saying this, competing for that work. There aren't that many people now that die without a will in Spain, but where we find it happens most often is people that bought like 30 or 40 years ago. And in those days, the lawyers would not sort of push them to sign a will when they did the conveyance, and sometimes they sort of slip through the net and they end up without a will. So I'm sure you've seen. I mean, the other thing to say is that Spanish people, English people, they come over, they say, "Oh, we don't know. So strange. There's these odd properties that you see, they've just been abandoned in Spain. Does nobody want them? Can I buy them on the cheap?" No, almost all those properties are the product of people that died without a will, with a will that was a mess. That's why those properties are normally that way, and normally they just haven't got a solution. Probably that's probably the situation. Yeah.
Okay, Pedro. Michael, thank you. Pedro, would you like to comment something before we jump on to questions? Michael,
yeah, well, let's
the questions.
I'm just starting reading the questions, and one of them is just linked to what we are saying. It's from Natalie. Thank you, Natalie, for the question. It says, our notary informed that our will in the Netherlands covers our assets in Spain. Our kids are the beneficiaries, and they are adults by now. And the question is, it is necessary to have a will in Spain? I think it's been well explained by Michael. I mean, it's not an obligation. Obviously, a will in Netherlands, in this case, is absolutely valid in Spain to cover the assets in Spain. But what we normally recommend to make a will in Spain in order to do things like a straightforward, whenever something happens, in order to, because we will have to wait until in Netherlands or in a different country to have a declaration who are the beneficiaries. If that will also will have to be made also a declaration by a court in order to decide, to prove who are the beneficiaries, in order to be able to do it in a notary office. And then all this will increase the complexity, and obviously will increase the cost in Netherlands, in Spain. But it's absolutely valid to have a will if, because in this case, Natalie, I understand that you are non-resident. But if you become resident in Spain, that thing may change. I'll tell you why. Because when you move into Spain, the applicable law maybe is the Spanish law. In your case, because your beneficiaries in your will is the children, will not change really too much. But for those cases that maybe between you give everything to your spouses or to someone else, and then substitution your children or your children to be in the second step, when you become resident in Spain, the applicable law is a Spanish law, unless you decide to choose expressly your national law, in this case, your Netherlands law or UK law or any other law that you have a nationality, are you a citizen of that country. So if you are non-resident, well, if you have a will or you don't have a will, obviously the process of inheritance will come through your national law. But if you become resident, it's something that we highly recommend to do it with a will. It's not an obligation, but it will reduce complexity at all. Okay.
Let me just add one more thing, Pedro. I do not see any reason whatsoever why you wouldn't do a will. I mean, we might be lazy. We might leave it for a different day. I'm not ready to go. A lot of answers to that, but I don't see any benefit at all on not having a Spanish will. I mean, is it compulsory? No, up to you. But I'm sure you don't want to leave everything into a difficult, expensive probate, and I'm sure you guys will agree. So that's, I mean, I still think that whoever didn't have a will yet, according to personal law, could benefit. Because the problem, you don't think that if something happens to you, then we need to do all the probate from your home country. That brings dealing with another lawyer, dealing with another notary, dealing with the translation, apostille. All that is unnecessary if you made a will, and if your will is according to law. Plus, if you, as Pedro said, if you're a resident in Spain, you could use either a Spanish law or your home country law, whatever it benefits for the purpose of your will. Saying that, I'm sure Michael wants to add something. He was saying.
Yeah, I mean, as I say, we've sort of done it. We did a series of videos which we call Inheritance from Hell. I think we're up to number 49 now. They're just little examples of things that have happened over the years. Some cases just a question of a whole load of inheritance tax to be paid, and other times it's other kinds of disaster. But just on the basis of what Pedro has just brought up, which is very important, let me give you a little example. A couple in Spain, they've got their property in joint names. They don't bother to make a will, but they're residents here in Spain, okay? So they've got their small house here, 220,000 euros worth, and they've got their bank account. Now one of them passes away, hasn't made a will. Now, Directive 650/2012 determined that there is no choice of law, and there won't be because there's no will. The law that's going to be applicable to that intestate process is going to be the law of the last residence. So that's Spanish law. Now, Spanish law determines there's some small details to this, but basically, in essence, the children are going to receive, the spouse is not going to receive her husband's half of the property and half the money in the bank account that was in his name, because roughly the children are going to receive 2/3 of the estate, 2/3 of the husband that's passed away estate. Now that shocks her, because in the UK she would receive up to £270,000. There's no argument. It would all just go to her, because that's what the intestate rules say in the UK. It's completely different. So that lady, for example, and this is a real example, she now is trapped. She can't inherit, and she tells me, oh, I don't get on with my kids. One lives in Australia and the other one doesn't talk to me, and it's a disaster. What do I do now? Well, there's nothing we can do. She's literally trapped. She's in the house. Of course, nobody's going to move her out because nobody's going to come over and do anything. But at the end of the day, she can't sell the property. Okay, and that is just a real scenario that can happen to someone that hasn't got a will anyway. Other situations, no Spanish will, but there is a UK will. And now the UK will mentions a trust, and mentions this, and mentions that. Trusts don't exist in Spain, so they can cause all sorts of problems when we're having to convalidate. And remember, we've got to actually wait. That will that was signed in the UK is not directly valid in Spain. It has to go to probate in the UK first, get sorted out there. Then we got to get the Hays Apostle. Then we got to get official translations. And then we've got to see how we deal with this business of the trust and how it was going to work. Because if the trust, for example, remember what I said before, that in Spain, what the beneficiary pays in tax depends on his relationship with the deceased. Now, if there's a trust that gives the faculty to dispose of the asset to somebody that's not the spouse or the children, even though the final beneficiary is the child, the taxman in Spain could interpret that there isn't any way that he can control that the final beneficiary is the child and want to tax it and not allow the exemptions. In other words, things can get really messy, and it's just basically absolutely unnecessary because of how easy and relatively not very costly to make a Spanish will. That almost brings me to the other hot subject that we've got at the moment. I don't know if you've heard about it up there in the Valenciana region, all the mess that we're all going to have now with the TIE cards and the residencias for people, because in the EU now, they're going to implement the obligation of the biometric identification, etc., etc. Lots of people, when the Brexit deal was done, and all three of us have been on panels with the British consul, the British vice consul, and all that. And the official position was it was not obligatory to request a TIE card because of the withdrawal agreement. If they had the green little certificate or the green little card, they were okay. It wasn't obligatory to think. But they were trying to say between the lines, but all three of us have always been saying, I reckon it would be better to get the TIE card if it's on the table, because Spanish people got identification card, just get the TIE card. It's not obligatory, not obligatory. And you had all these people saying to the consulate, well, is it obligatory? And no, it's not obligatory. And you can see it's all over now. Now they're recommending on the British consulate, they're actively recommending that people get the TIE card. This is the same as the will. Is it obligatory to have a will? No. Is it convenient for you? Absolutely yes. There is no point in arguing it out, and you have the odd solicitors in the UK saying, oh, it's not, we can do, you can deal with this, the Spanish estate using this will. It's not the right advice. It's just, people need to have a Spanish will. That's
that's I agree, Michael. And to be honest with all you, the whole point of the will is to make the life better for the beneficiaries. So I don't see anywhere around a better way that you instructing your executors, your people, discussing with a professional the best tax efficient way at the time you make the will, even changing or review it in a later stage in case of changing the circumstances, changing the taxes, because this is, unfortunately, this is not a solid thing for one specific moment. The laws could vary and change. So first advice we will say here, please do have a will for your own benefit. Pedro, you were going to say something about a question, correct? You were asking to say something about one question?
Yeah, it is just to, I was going to read one of the questions that we have to both of you. It says from Maland. It says, my wife and I are full-time tax residents in Spain. We have a Spanish will, in this case, have a Spanish will to cover Spanish assets, house, and bank account. This is what a very typical case, really, on that residents in Spain. They have a Spanish will to cover the Spanish assets, and says, we also have a UK will to cover UK assets. We have no children, and each will leave all of the assets to the surviving spouse. Are the UK assets liable for Spanish tax, or it is only UK tax? I'm asking to both of you.
Sorry, what? I lost it.
It is a typical case. Ignacio and Michael is really residents in Spain, have a will in Spain.
What's the timestamp on that, Pedro, so I can read it?
It is at 1742. So it is this is a case that is, I think it's very typical. Residents in Spain, they have a will in Spain for the Spanish assets, they have a will in the UK, and they are giving each other a survivor and spouse all the assets, and they have assets in Spain and assets in the UK. So the beneficiary in this case, the residents, is residents in Spain. One of the spouses will be residents in Spain whenever it happens to the other spouse. So it is just a matter of obviously.
Okay, I can go through that one if you want. Okay. That one there. Okay, so the question is, my wife and I are full-time tax residents in Spain. We have assets we have a Spanish will to cover Spanish assets, we also have a UK will to cover. We have no children, and each will leaves all to surviving spouse.
The resident is in Spain, so obviously
are the UK assets liable for Spanish tax, or is it only UK tax? Okay, this is a very normal question. And a lot of people get it really, really wrong. Okay, so let me give you the point of view from Spain and then the point of view from the UK. So if the beneficiary is a resident, they've got to declare, in other words, they will, as they've got two separate wills, which is the correct thing, they'll use the Spanish will to distribute the Spanish estate, just the Spanish estate, okay, from a civil point of view. But when the beneficiary, who's a resident, declares the inheritance tax, in Spain, they're going to have to declare worldwide assets. Now, once they've done that, what will happen is they've got to then, there's one point where it says that they can claim unilateral relief on the tax that's being paid in those other countries on those assets outside Spain. Now, beneficial residents. But what we're going to go to now is a very deep rabbit hole that people don't quite understand the concept. And now this is very complicated now, because that is, in Spain, it all depends because your beneficiary is a resident. In other words, the Spanish side is really clear what has to happen. From the UK side, things get really, really murky. Why? Because in the UK, if the deceased was deemed domicile, which is not the same as being a resident, in other words, you can actually have left the country some time ago, but still be considered deemed domicile. And it's a very dangerous figure, this deemed domicile. And for that, we're not allowed to give you advice because we're not English lawyers, we're Spanish lawyers. You'd have to consult on a lawyer to see whether you could still be considered deemed domicile. If you've left the country many, many years ago, there's probably very little risk. But if you've left recently, it could be very problematic because you could be in Spain as a resident and still be considered deemed domicile. What happens if you're considered deemed domicile in the UK? Well, it means that apart from, because remember in the UK, it's the estate that pays the tax, apart from declaring the assets. Now, you go to probate on the UK assets, distribute with the UK will, but when you declare the inheritance tax, if you're deemed domiciled, the estate has to declare inheritance tax on worldwide assets and then apply unilateral relief could that be to be granted regarding the assets that were in other countries on which you've paid inheritance tax in other countries. So what can actually happen here? And it sounds so nasty that sort of people who don't even want to sort of think about it in reality, but there are some people that can fall into a tremendous situation where they've moved out over to Spain. They've only just been here little time. The beneficiary is a resident, says, oh, great, I live in Andalusia or in Valencia region, and I'm going to receive 2 million from my spouse. I'm going to pay almost no inheritance tax. But in the UK, they wind up their estate there, whatever's left over there, and the lawyer says, were there any assets abroad? And then you say, yes. Then he wants to know what they were, how much tax is being paid. And the next thing he says is, this person is still considered deemed domicile in the UK. But don't worry, because you won't pay tax twice. We want to know what tax the lawyer Michael Davis has paid for them in Spain, and I will just deduct it in relation to those assets. But there was no tax paid in Spain, or almost none. And now they're going to tax them in the UK on that 40% above the threshold. So this is a reality. In other words, it catches people by surprise. They think, well, how can that be? Well, that is the way it is. Something different is if they just choose not to declare the assets in the UK or whatever, but technically that is what happens.
Okay, thank you. Pedro, will you go for the next question, please?
Yeah,
and then,
let's go.
Because we have many questions. And I guess
my wife and I are tax residents in Casablanca, and our property is in our joint names, and our son is non-resident and he has an IN number. We have a Spanish will to leave our property to our son. Well, okay, would it be beneficial to sign the property to our son now? He's 42 years old. Well, I normally do not recommend to leave our gift properties to children once you are still alive, because you may want to sell it and then buy another one. I don't like clients to be tied on decisions of the children. Obviously, I don't want to enter on the relation of parents and children, but I personally always recommend clients to keep the assets. Obviously, in this case, there is no beneficial really, because the gift rates are the same as the inheritance, so there will not be any beneficial really on this. As in general, I understand if there are some other issues, there are some other questions that may arise on this situation, good, but as it is explained by this person, I don't see benefits on this. I mean, it just leave it as it is. If you leave your assets to your son, then will be one of the spouses will be 50% of the owner of that property, and the other 50% will be given to your son. and then will be that co-owners, the spouse alive and the son. Well,
Pedro, let me just add one more thing.
Yeah.
Actually, I agree with your comments. I mean, I always concentrate the advice on you guys because it's your money, it's your assets, and it's your probably cover. So probably I'm more of the opinion of if you need to wind up pretty much or sell or have the money in the bank or invested or whatever money is left, it can be always transferred to your beneficiaries anytime. But once you probably donate to someone, you don't know what is going to come back if you need it. So it's more of a civil thing. The question will be, will you ever need that money? I don't know. Would they ever give it back? I don't know.
Let me add one thing, important issue on taxes, on gifts, because many people say, I'm going to give this to my children. Okay, perfect. Imagine that I buy this pen on €1. And after 10 years, this pen costs €20 because the value has increased to €20. And it cost me €1, and now I'm going to give it to my son. And I say to my son, I'm going to give you this as a gift, this pen of €20. The value is €20, and it's free, it's no taxes, perfect. And my son will be fantastic, glad, but I will be paying an income tax for my gain of €19. So imagine that on this is a very small value, but imagine on properties that someone bought a property of €100,000 and now it's €300,000 value, and it's given to the son, a gift. I'm going to get a gift, and the gain of that property, whoever is going to give in this to the gift, it will have to pay income tax declaration, and that will go. I mean, that would maybe a lot of money, even though you save on a gift tax, you will be paying an income tax if it has a gain. Obviously, you don't receive any money because you are giving it, but you declare it in an income tax declaration. So it's so whoever is gonna be thinking about making a gift to whoever is something very, very important that needs to be checked.
Another extra thing, Pedro, even another extra thing. I mean, I don't want to be twisted here, Michael, but we don't know where all we're going to go. So exactly. Who knows whether you give it to your children and something happens and he didn't make a will, Michael, and Pedro. So, oh my goodness. So do I need it back? So, I mean, I'm not trying to scare anyone, but I'm trying to say, let's do it if we're really convinced we don't need that anymore, basically.
Yeah, well, I've always been of the inclination of not recommending donations in general. There can be the odd exception where it may be worthwhile. There are some people that have got very large estates in the UK, and they've got an inheritance tax on because they're still domiciled in the UK. And if they donate the property over in Spain and they survive the 7 years, it removes that asset from the total value of their estate later on, because if they're domiciled in the UK, they've got to bring all these assets into the estate, and after 7 years it wouldn't be pulled in. The other thing is that we've had some wealthy Spanish families that, because they know the inheritance tax has changed over the years back and forth, they've sort of tried to hedge their bets a little bit and sort of donated some assets over. But of course, being very careful, and as Pedro's been very correct in pointing it out, because not everyone does, and we've seen this, the business of the underlying capital gains tax. It's very, very important. We've seen in these videos that we do, Inheritance from Hell, because it's all about estate planning. We've actually got one with that example. It's donation from hell as an estate planning strategy, and that is because when they brought down the donation tax in Andalusia, lots of people jumped into doing these donations we've seen a case in particular where the lawyer did not explain to them that apart from the donation tax, which indeed was close to nothing because the 99% deduction, what they didn't explain to them was what their underlying capital gains tax bill was going to be, which they received a few months later, came to see us about it, and of course there was nothing that we can do. I mean, if the person that's doing the donation, he can make use of he's over 65 and it's his main home, you can do that. There's certain, but if there is a little bit, and if you've got some with our Spanish clients that have wanted to hedge by donating some of the assets over, what we've done is chosen those assets they've not got a large underlying capital gains tax and donated those assets rather than the other ones. It has to be done with carefully. But in general, it's as you say, I think the policy of not donating is a better one. Over the years, we have seen the odd client of ours get very upset because after doing a large donation, on their next visit to the office, they've sort of just on the, as we're just chatting around, explain how their grandchildren seem to be coming out less often to see them now that the house belongs to the children already. It does actually happen because it's human nature. Sometimes it doesn't mean that the son is a bad person or anything. It's just that he's got all this stress in life and problems and trying to make sure he's got enough money to pay for the kids' university. If he knows that that villa in Spain is dependent on him taking the grandchildren out, even if it's so he can take care of his own kids, he ends up going out there just to make sure the villa doesn't get left to his sister. So it just happens that way. So.
Right, I've got a good one here, Pedro Michael. There is an urban myth. This is Gary, amongst expats, that if a death is not reported to and known by authorities for 6 years after the death of a person, inheritance tax, etc., is avoided. Who wants to take this one?
I can take it if you want, or Pedro.
Well, it
Pedro,
is
go for it.
in many occasions inheritance tax will be very low, very low. I mean, obviously, we need to be checked if what is the region and was living the deceased person, or where are the beneficiaries. But in many occasions will be very low, almost 0 years in many occasions. But the voluntary period to declare inheritance tax is 6 months from the deceased date. And from that time, so 6 months plus 4 years will be the prescription date. So it means that after 6 months plus 4 years, 4 years and a half, after that date, there will not be tax at all in order to pay if it's not reported. If no one knows, if nothing, no tax office do not says anything, do not interrupts the period of time. Well, if nothing happens at all, then will be 4 years and 6 months. But it says 6 years. I don't know what it says.
No, probably he got confused.
6 months, yeah.
He got the confusion. But Pedro, nowadays, as I'm saying, nowadays is very good in Andalusia, in our region, in Valencia, in Balearic. But we don't know what's going to happen tomorrow. So I remember those days where people did not have the cash, the liquid money to pay, and they did nothing. And if taxman did not do anything, then the tax expires. I'm sorry, but your time elapsed. Yeah. So nowadays doesn't make sense. But who knows tomorrow what is going to be the bill?
Yeah, so, I just want to point out on that. So yeah, we've seen deeds in that years ago, people that simply just couldn't afford it, not necessarily doing it in debt, they just couldn't afford it because inheritance tax was very high. And often before the data, before the big databases and things like that, especially when people died in the UK, they died in the UK. So 4 years and 6 months went by, and you can claim a statute of limitation. We've claimed a few over the years, and it did work. Nowadays, if the person actually passes away in Spain, with all the databases and things, it's quite difficult for the taxman not to find out, even though it could happen. And what people do need to be aware of is that the taxman has a habit of writing to you just before the 4 years and 6 months are up. And the longer that's gone by without you declaring it, the higher the penalties are going to be. So I would say that this is not like a good option, if you like, in general, not a good idea. And definitely not a good idea if somebody passes away in Spain. The thing is, there are all sorts of ways now the taxman can, even if you pass away in the UK, because the banks, for example, freeze your account if the passport comes up for renewal. They write to you and they can't get hold of you. They put a note on the account because it gets blocked, and you never know how all these things what the interaction is with the taxman on all these things. So less chance of it working than in the past, but what that friend is saying, in the past definitely did happen. Let's put it that way. Yeah.
Right, Michael, Pedro, I've got another good one. Edward is saying, interested in taxation of an inheritance received by a non-EU citizen resident in Andalusia from a US citizen resident in the USA, with all the property located in the USA. 551. Who wants to take this one here?
Sorry, which one
Pedro,
is it?
Michael?
Five.
It's
I'll take it.
551. Edward, interest in taxation of an inheritance received by a non-EU resident.
Okay,
In Andalusia.
I'll take
Yeah?
it. It's
Sure.
a non-issue in Spain, because if the beneficiary is a non-resident of Spain, he would only
Good.
declare in Spain the assets that he's receiving in Spain. So he's a non-resident, and the assets he's receiving are outside Spain. It's a non-issue in Spain. It doesn't have to be declared.
So it's good news.
Good news, yeah.
Right.
Unless it's a mistake on the question.
Okay. Pedro, do you want to follow?
Okay, let me just run some questions. It says, Alexandre says, main residence of whom? Main residence of the heir of or the deceased parents, obviously the main residence of the deceased person. What would, in Comunidad Valenciana, in Valencia region, this benefit of a 95% of the value, reduction of the value of a property up to maximum 150,000 euros, is if you keep the property 5 years. The beneficiaries keep the property 5 years. Okay, let's go.
Right, I have another one here, 552 here. If you have an English will and a Spanish will, can you make the English will the principal controlling will? I don't know whether it will be worth it.
No, you don't. No, you don't want them to cross, because that just creates complications. People get very confused because the Spanish will nowadays, you need to make a choice of law on it. Say that I choose my English law, but that's not choosing the. Some people think that's choosing the English will to take. No, that's not. Just choosing the English to determine how you can distribute the estate, and they get mixed things up. For the two wills to serve the purpose, the Spanish will needs to say it's only in reference to the Spanish assets, and the UK will only reference to the UK assets, and you just need to make sure that one doesn't end up revoking the other one. So if the Spanish one is done after the UK one, it must just say it's only in reference to the Spanish estate to avoid it revoking the UK one, and vice versa. But you don't want to, you can't tie one into the other, or that's not possible.
Right. Okay. But it is important that you mention in the will what is the applicable law, what are your wishes, and whether the assets are located in Spain or abroad. Okay. So you could give instructions in Spain with a will, in the UK with another will. Okay. Now, Pedro, Michael, would you like to carry on?
Yeah, let's go. One other question I think is being made by Peter. Is something about shares of a private trading company in the UK. This company is subject to exemption in inheritance tax in the UK. And he wants to be resident, in this case, in Menorca, which is Balearic Island. Next year, what are my liabilities for inheritance tax in Menorca and family business, given the same exemptions? In this case, in Balearic Island, it was changed also exactly the same as it was in Valencia region or Andalusia in the past. Some changes in this case will be fully exempt, 100%, fully exempt in this specific case. Group 1 and Group 2 do not pay in this case. And well, that's a good issue. That good news also for Balearic Island in this case. I think I have answered this question. It's 100% deducted, so it's not included. It's exempt in this case. What else? Let's go to.
Shall I take 1755? That's a good question.
1755.
So
go for it.
I have a Spanish property. I live in the UK, non-resident of Spain. I'm 60 years old and do not have a spouse or partner. I'm single. I do not have children either. I do have one sister a few years younger than me. I have an elderly father in his late 80s. Both of them live in the UK. As I would like to leave my Spanish property to my sister and father, and also to a charity in Spain, split equally between the three of them. Is this doable in Spanish will, and what tax will everyone pay? Okay, I'm not sure if you said here where the property is in Spain.
That's important. No, it doesn't say that.
Okay, well, anyway, it doesn't matter. If it's in the Canary Islands, Andalusia.
Yeah, Spanish property, Michael. It says it's Spanish property.
Yeah, it doesn't say what
region, yeah.
If it's any
it doesn't say the region. Yeah,
if it's any of the inheritance tax, the following regions, Valencia region, Andalusia, Balearics, or even Madrid region, the situation would be, yes, you can leave it to these three people, and the taxation would be, if you leave it in three shares, the mother or father, not sure what it says here, wouldn't pay any inheritance tax in either of those three regions. the sister would pay inheritance tax because they're going to be a group 3, so depending on the value of the asset, and the charity, if it's a registered charity, would not pay any inheritance tax. The charity wouldn't pay inheritance tax regardless of where the property is. So that would be it in a nutshell. If she wanted to, in a case like this, for example, if this was like a very large estate and she came to us and said, I wanted to do this, she's better off leaving everything to her mother than to her sister, because she leaves everything to her mother. She passes away. And later on, the mother, when she receives it, makes a will in favor of her sister. The transfer from daughter to mother's got no inheritance tax, and from mother to daughter's got no inheritance tax. And yet, from her to the sister, it is subject to inheritance tax. So, depending on the value of the estate, and therefore how much it's worth complicating things, that's sort of the angle I would take.
Right. Okay, Pedro. I mean, we're having a lot of questions.
We have a lot of questions.
I think Pedro, Edward said no. My question said the person is resident in Andalusia. You remember the American question? My question said the person is resident in Andalusia, but the decedent and the property is in the EU. I understand. In the EU.
Sorry, yeah. Which one was that? Yeah, that makes
624 linked to the one that he.
Okay. Okay, I've got it here. Okay, so oh, sorry. Yeah, I beg your pardon. I read it incorrectly. Yes, non-EU citizen, resident under the. Okay, that's a great question. Now, then, that way, it's a really good question. Now, the question makes a lot of sense, and a lot of people ask about it. Why? It's because of what I sort of explained before, which maybe our friend didn't actually edit, and that is the confusion there is surrounding non-residents and whether they can claim the regional exemptions or not. Now, the reason it's confusing is that we've gone through 3 different systems over the last 7 years. Initially, non-residents could not claim the regional exemption, so he would have been subject to lots of inheritance tax. So received by... Oh, sorry, wait a minute. He hasn't mentioned, though, who he's receiving the estate from. So I don't know what group he's in. We need to know. He needs to tell us who he's receiving the estate from so that we can answer it correctly.
The mother, Michael.
From his mother. Okay, great. Okay, so he was receiving the estate from his mother. In the old days, as a non-resident, he'd have to present the inheritance tax return to the National Tax Office, and he'd only be entitled to €16,000 exemption. Otherwise, he'd have paid a lot of inheritance tax. Then the EU told Spain they couldn't do that to...
But he's resident, Michael. Yeah, he's resident in Andalusia.
Sorry?
He's resident in Andalusia.
Okay, so it's really easy. I'll just answer that. Okay, so if he's a resident in Andalusia, he presented to the regional government in Andalusia. He's got €1 million exemption if his pre-existing wealth is less than €1 million. But in any case, above the €1 million, he gets a 99% discount. And if his pre-existing wealth is more than €1 million, he doesn't have the €1 million exemption, but he has a 99% deduction on his full tax bill. So yes, he does have to declare a 650 form within 6 months of the death, but he's going to pay almost no inheritance tax.
But Michael, Pedro, now we're lucky that residents in Spain, in most of these communities, obviously Andalusia, Balearic, and Valencia, if you're a resident and you have a big inheritance, there are big allowances, and you probably nowadays you don't end up paying tax. Now, if the beneficiary, as you say, is abroad, obviously, is up to the laws in the country abroad, so nothing to pay here except any property as non-tax resident. So I think residents in Spain nowadays, thank God, they're in a very good position, Michael, Pedro. I think we're in a very good position.
The non-residents have to declare in Spain to the National Tax Office, but claiming the regional exemptions where the majority of the assets are situated. So in Spain, if they're inheriting in Andalusia or Valencia region or Baleares from a group 1 or 2, now spouse, children, or parents, then they're going to pay almost no inheritance tax or no inheritance tax in Spain. What we're not talking about here is what happens in those other countries, because we can't talk about that.
No, we don't know.
In Spain, the non-residents now get a really good deal if they're in group 1 or 2 in most regions.
Right, Michael, Pedro, will you go for the last one? Because alternatively, they need to send you an email or even do a consultation with you. I don't know. I mean, we're covering a lot of points, obviously, personal law, wills. We're talking about resident, non-resident, community bylaws. So it could be quite complex, or alternatively, it could be quite simple. But as I said, the number one advice is to make a will, because that's the way to go. Then secondly, to work out or do tax planning, as we could do now. Pedro, Michael, would you like to say anything about any specific that you could think is general, well, specific, but in general terms that affect people? I think we covered most of it, didn't we?
I think, I mean, it's a lot of there are a lot of questions that I always we would like to answer, but it's impossible in 1 hour to answer them. We have dozens, probably a lot of questions.
Okay, I'll wrap up then.
I encourage and I tell people to send us an email, and we will be able to answer them by email. As there are some of them that are really interesting in order to cover. Anyway, I mean, obviously it's important to plan, and I mean, to make some obviously queries and plan what is going to happen with your assets in Spain whenever you have invested, or if the beneficiaries are residents in Spain. Important to make a estate planning on what will be the taxes, what will be the inheritance tax, what will be the best situation, the best scenario, in order to cover and to protect who are going to be the beneficiaries. When we make and recommend to make a will, on most of occasions, obviously is to protect that the beneficiary will receive the assets that the deceased person is going to give whenever they pass away. So the beneficiaries will be protected. And obviously about taxes is extremely important. If someone is a resident in the UK and their assets are in the UK, so will not be reported really in Spain. But if the assets are in Spain and a resident in Spain, the beneficiary is obviously something that needs to be done, or is non-resident in Spain. So there are many situations that should be covered, and we work on this every week with clients in order to make simulations, in order to inform them really. And they are, in many cases, they're surprised. Oh, I thought it was going to be a lot more money on taxes, and it's really low. It's sometimes ridiculous. Sometimes it's something that it's not relevant in order to make one decision or not. Yes. So, but it's important to obviously to take advice on this. And in this case, as inheritance tax is regional, I'm recommending obviously to cover to someone who regionally knows how works this inheritance tax.
Okay, well, thank you very much, Pedro, Michael, for your time. For those who still have some questions, please feel free in the chat. You could see Michael's email, Pedro's email, and my email, and you could probably pass it on or even discuss in an hour consultation if necessary. Obviously, I always recommend, and it's cheaper to prevent the problem, always, so making a will, making a tax efficient will, giving instructions properly, even leave the executor the instructions, so in case something happens, they know who to contact, etc., etc. The more you could prevent, the better. Thank you, Michael, for your time. Pedro, thank you for your time as well. We hopefully see you very soon. Thank you all. This is going to be recorded. You can watch it back from tomorrow in our website, and I'm sure you can learn much more as well in Michael's website. Thank you again. I pass you on to Juanfran. He will have a video for you to remind you a few bits and pieces. Over to you, Juanfran. Thank you.
When a loved one passes, it takes time to assimilate losing them. At these times, when you least want to deal with paperwork, Pellicer and Heredia are here to help. One of our lawyers will be in touch to inform you about the process and answer all your doubts on the legalities. No matter where the assets and heirs of the deceased are located, and without having to travel to Spain, we can advise you and carry out all the required proceedings in Spain. Obtain the death certificate. Search for assets, debts, and existing insurance policies. Give advice on accepting or renouncing the inheritance in Spain. Hand over information on all the related costs. Pay all the compulsory taxes on your behalf, and translate all the legal documents required. And remember that upon death, when carrying out all these processes, legal deadlines apply. Through this difficult time, when you most need help, Pellicer and Heredia is with you every step of the way. Pellicer and Heredia, international lawyers.